For the past 2 decades, digital technologies have had an increasingly important impact on people's lives. EU regulators have often faced challenges when tackling new issues stemming from these technologies. Lately, the EU lawmakers have been adopting a number of new regulations to address these issues. The 2 first episodes of this series tackle the Digital Market Act as well as the Digital Services Act. In this 3rd episode, I shall interview Sébastien Fassiaux regarding the rapid uptake of artificial intelligence technologies and the EU's recent attempt to regulate these systems with a view to protecting consumers and fundamental rights. Artificial intelligence seems to have exploded into public debate recently. It's on everyone's lips. Is artificial intelligence actually a new technology, a genuine technology, paving new ways, breaking new ground?
Well, not really. In fact, artificial intelligence has been around for decades. However, we've seen in the past years a dramatic increase in computing power, in the availability of data, including personal data, and the recent boom of generative AI, such as ChatGPT and other systems.
How widespread is the impact of AI?
AI systems have not only become more powerful recently, they're also much more accessible. They're spreading now throughout different sectors, for example, in healthcare, in education, in finance, or in the military. Basically, their impact on society is far greater now than before.
In 2024, the EU lawmaker, the European Parliament and the Council of the Union, adopted the 2024 AI regulation. Were there any rules applicable to AI systems beforehand?
Yes, different sets of rules under competition or intellectual property law applied beforehand. But the most consequential regulatory framework has probably been data protection law, especially under the General Data Protection Regulation or the GDPR. Why data protection law? Because AI systems need to be trained on important data sets to operate effectively.
I understand. If the GDPR already applied to AI systems, why did the EU decide in 2024 to adopt a new regulation? Were there any gaps? Were there loopholes?
Well, the GDPR focuses on personal data, but many AI-related risks actually go beyond privacy. But in 2021, the European Commission deemed it necessary to propose a broader framework capable of addressing different types of risks, ranging from discrimination to police control.
Therefore, the proposal of the European Commission was adopted by the European Parliament and the Council of the Union. What is exactly this AI Act about? What's its content? What are the main obligations?
The AI Act is quite remarkable because it's the world's first comprehensive framework to regulate AI. Its main objective is to ensure that AI systems placed on the European market are safe and that they respect fundamental rights.
So in your view, Sébastien Fassiaux, the AI Act of 2024 is breaking new ground, it's been paving new ways.
Absolutely.
In the first episode, you explained that the 2022 Digital Market Act was complementary to traditional competition law. In the second episode of this series, you stressed that the 2022 Digital Services Act is about platform governance. Against this background, how will you characterize the 2024 AI Act?
The AI Act is closer to a product safety regulation. What does that mean? It means that before certain AI systems can be marketed or deployed, providers of these AI systems or their users must comply with certain requirements and ensure that their AI systems are safe.
Sébastien, you just stressed safety issues. Can you explain us what's the basic philosophy behind the 2024 regulation?
The AI Act follows a risk-based approach. What does that mean? That the higher the risk that they entail, the higher the legal requirements for placing them on the market.
But why the EU lawmaker decided to endorse this risk-based approach?
Simply because not all AI systems entail the same risks. An AI tool that recommends music is very different from one that helps decide whether someone gets a job or a loan.
If I understand you correctly, Sébastien, there is no one-size-fits-all regulatory approach. Did the EU lawmaker distinguish between different categories of risks?
Absolutely. Broadly speaking, the AI Act distinguishes between 4 categories. The first one deals with prohibited AI systems. The second one with high-risk AI systems. The third one, limited risk AI systems which are subject to transparency obligations. And the fourth one, minimal risk systems that remain largely unregulated.
4 categories. We should definitely delve into them. Let's begin with the most serious category. What kinds of AI systems are prohibited?
The systems that are prohibited are considered unacceptable in Europe because they create excessive risks for fundamental rights. Examples include the inference of emotions in the workplace or in education, or also very manipulative AI practices and systems. However, the AI Act does not apply to military applications and, for instance, does not cover automated weapon systems.
That being said, most of the discussion seems to focus on high-risk AI, so the second category. What does that category include?
These are AI systems used in particularly sensitive areas, such as employment, education, healthcare, critical infrastructure, law enforcement, and migration management.
Sébastien, why is employment considered or classified as high risk?
Because AI systems used to screen job applicants and evaluate workers can have a major impact on people's lives. Errors or biases can directly affect access to employment opportunities.
AI systems classified in the blacklist are prohibited. What obligations apply to high-risk systems? What must providers of high-risk AI systems do?
They must comply with extensive requirements. What are they? First, they need to manage the risks of their AI systems. Then they need to ensure that the data that their AI systems are trained on is of good quality. They need to ensure human oversight. They need to keep documentation around their AI systems, make sure that their AI systems are transparent, and even more importantly, monitor the risks of these systems throughout their life cycle.
Much of the public discussion focuses on tools like ChatGPT. What about generative AI? Where do they fit into the AI 2024 Act?
The AI Act includes special rules for general-purpose AI models and generative AI systems. These rules focus on issues such as transparency, again documentation, and compliance with copyright-related obligations.
So it means that generative AIs fall within the scope of the Act.
That's correct.
So far, we discussed the prohibited AI systems, the ones that are also regulated in light of due diligence obligations because they are classified as high risks. Some AI systems barely regulate. What about this lowest risk category?
Many everyday applications, think of spam filters or recommendation systems, actually remain largely outside the strict regulatory framework put in place by the AI Act. Why is that? Because their potential risks are considered relatively limited compared to the others, and other regulations already deal with them, such as the DMA and the DSA that we discussed in the 2 previous episodes.
To the best of my understanding, the AI 2024 regulation classifies the AI systems according to their respective risks. It seems to me that the regulation applies to manifold actors. Why is that?
Because AI systems involve complex value chains. The AI Act therefore imposes obligations on providers, which are the developers of these AI systems, but also on deployers, which are the users, and on importers, on distributors, and on other actors depending on their role.
Why on earth the EU lawmaker felt the need to oblige all these categories of economic operators? Why not simply regulate the companies that develop AI systems?
Because risks can arise at different stages. A company that develops an AI system is not always the same company that deploys it in the real world, and both may influence how risks materialize. Also, it's not only about companies, because the AI Act applies both to the private and to the public sector.
Many human rights lawyers are afraid that this new technology will impair human rights. As you are aware, Sébastien, human rights are deemed to be a core value of the European Union. They are enshrined in Article 2 of the Treaty of the European Union. One concept appears through the Act, fundamental rights. Why did the EU lawmaker afford them so much importance?
Because the EU sees AI not only as a purely technical or technological issue, but also as you just said, a human rights issue. AI systems can affect privacy, we've already discussed it, but also equality, freedom of expression, due process, and many other fundamental rights.
Did the EU lawmaker multiply firewalls with a view to protecting human rights? When it comes to discrimination, can you give us a concrete example, please?
Imagine an algorithm that is used for recruitment in companies or in the public sector. If these systems are trained on biased historical data, they may discriminate against certain groups. The AI Act seeks to reduce these risks through requirements related to data governance and risk management.
Accordingly, you are of the view, Sébastien, that this AI system could wittingly or unwittingly give rise to discrimination.
It has indeed been one of the key concerns of the EU institutions.
As you are aware, Sébastien, the Human Rights Charter of the EU provides for a right to data protection. Is the GDPR still relevant after the implementation of the AI regulation?
Of course, and the AI Act does not replace the GDPR. It creates some exceptions, for example, to train AI systems on sensitive personal data. But in many situations, both regulations apply simultaneously and complement one another.
In the course of the negotiations, several member states worried that the AI Act could stifle innovation. Why?
Because compliance can be costly, especially for smaller companies. Some member states, as Germany, France, and Italy, fear that excessive regulation of AI could make Europe less competitive in the global AI race.
It occurs to me that on the US side, the development of AI is unfettered. Is there a trade-off in Europe between innovation and regulation?
Not necessarily. Supporters of the AI Act argue that a well-conceived regulatory framework can actually increase trust among consumers and create a more predictable environment for innovation.
Your answer raised the issue of legal certainty, a general principle of EU law. As you're aware, AI evolves incredibly quickly. Is there a risk that such a regulation will become obsolete quite soon? Is there a risk that there will be a breach of the principle of legal certainty in case the regulation has to be constantly adapted?
Here you are pointing to an important trade-off, one between the adaptiveness of the regulatory framework and legal certainty. The AI Act strikes a balance between these two constraints. Especially, it establishes an evaluation and review mechanism that is designed to allow the framework to evolve as technologies and risks change over time.
You mean, Sébastien, that the EU lawmaker was aware of the need to readjust the AI Act to evolving technology. So you just mentioned assessment, evaluation. How that will work?
Well, the Commission is obliged to assess periodically whether the lists of prohibited AI systems and high-risk AI system is still adequate. Then the European Commission must submit its assessment to the European Parliament and the Council and make proposals in case the lists need to be adapted.
Listening to you, Sébastien, it occurs to me that the EU can be described as a global regulatory pioneer when it comes to AI. How does the EU approach differ from that of the United States?
The US has so far refrained from adopting a comprehensive AI framework at the federal level. Instead, some US states, such as California, have adopted rules to regulate specific AI applications. For instance, in California, a new law was adopted to regulate AI companions.
If I understand correctly, California is filling the gap.
At least California and other states are trying to fill gaps in the absence of federal legislation, but they are regulating very specific AI applications.
In January 2025, a Chinese company, DeepSeek, released a new AI. Everybody was taken by surprise. Is the regulatory approach so different from the EU one?
Well, contrary to the US, China regulates AI actively. but with quite different priorities than in the EU. While the EU places particular emphasis on human rights, Chinese regulation focuses more heavily on social stability, on security, and on state oversight.
Human rights are thus not a main concern for the Chinese authorities. In 2024, the European Parliament and the Council of the Union adopted this AI regulation that has been paving new ways in the digital field. That being said, the EU lawmaker can intervene, can lay down new rules, provided that there are specific competences granted by the treaties to these institutions. Such a legislation must be adopted in accordance with specific provisions of the founding EU treaties. Can you explain us what are the legal basis of the AI 2024 regulation?
There are in fact two. The primary legal basis is the EU's internal market competence. This one seeks to harmonize the rules between member states. But the regulation also relies on Article 16 of the TFEU, a provision that confers the EU institutions a specific competence to protect personal data.
Accordingly, the AI regulation pursues a two-pronged approach. On the one hand, the functioning of the internal market, on the other hand, the protection of personal data. Do you believe, Sébastien, that the AI regulation is likely to influence lawmakers in third countries along the Brussels effect?
Potentially, yes. Economic operators often prefer operating under a single global standard. Therefore, European rules can end up influencing practices by companies, but also legislation far beyond the EU. But so far, not many jurisdictions have adopted such comprehensive frameworks. South Korea, for instance, is the only one which has done so recently with the adoption of an AI Basic Act.
In the two previous episodes, you highlighted the added value of the Digital Market Act and the Digital Service Act. In your view, is the Artificial Intelligence Act really paving new ways?
For me, yes, because the AI Act is not trying to regulate all AI systems in the same way. In other words, the EU institutions have avoided adopting a one-size-fits-all approach. The core idea of the AI Act is simple. The greater the risk an AI system poses to society, the greater the responsibilities imposed on those who develop and deploy it.
Thank you very much indeed, Sébastien Fassiaux, for intervening in this series of podcasts dedicated to the digital age. This series is funded by the EU Agencies for Education.
Thanks a lot for inviting me.